Howdy, Texas real estate note investors. Casey here, wanting to talk about Senate Bill 43. This came into play on January 1st of 2022. At the end of 21, it was voted on and enacted and became law here in Texas on January 1 of 2022. A lot of people have been talking about it recently for some reason, and so I thought I'd make a little video sharing my thoughts, takeaways, and reason that it is such an important bill and how it changed things here in Texas. A little backstory: as we all know, one bad apple can spoil the bunch, and that's what happened. We had a bad investor out in El Paso that went and took about $2.5 million in down payments from buyers, wasn't paying underlying debt, and all those families got foreclosed on. I hope he is tar and feathered and dealt with appropriately, because that is not how you do this industry. You do things ethically, because it's a lot better to do it right and build a sustainable business and a reputation you can be proud of. And that's what we're going to talk about here, is how you meet this requirement, go above the standard, and make sure you're doing things ethically and legally to protect yourself and to protect your end buyer. What I'm going to talk about is not everything that this bill goes over. I'm going to go over what I consider the highlights. I could not encourage you more to read the actual bill. I'm not an attorney. I don't like to read, but it is more than worth it. It takes about 20-25 minutes to get through the whole thing, and you're going to see a lot of information in there that you really should be aware of if you're going to be doing wrap loans here in Texas. I'll put the link to the bill in the show notes, so be sure to click on it and give it a read. Do take note, keep in mind, this does come out of the Texas Finance Code, not the Texas Property Code, so it's structured a little bit different because you're dealing with wrap mortgages. What we're talking about here are wrap loans with underlying liens. There are a lot of different details to go over. What is a wrap buyer? Who is a wrap lender? When does this apply to you? All of that is why you should read the bill itself. What it does highlight is that any loan that you make to an end buyer where the underlying lien is not paid off at closing, the lender did not consent to sell to this new buyer, the loan was never assumed, and they are subject to that underlying superior lien position on their property. That's who we're talking about. People that are buying a home that had another lien that is not in their name on it prior to them purchasing it. Another rule of note: there has been differences in the SAFE Act and Dodd-Frank, etc., on how many properties you have to do in a 12-month period to be subject to all these requirements. It's been 3, it's been 5. This bill did nail it down at 3 properties within a 12-month period. All of these things you're subject to, even if one was your homestead, all those kind of things. The best practice is to just always play it safe, always do the right thing. It doesn't matter if you do 2 or you do 70. Senate Bill 43 says that in order to do a wrap loan, you have to be licensed to originate a loan, which would mean you have to be an RMLO. That wasn't the original intent when they put the bill together, and it has since been clarified that you can use an RMLO, have them originate the loan. Once it's originated and done, they then assign the loan to you. A lot of big banks do this all the time. One bank will originate it, qualify the buyer, get some lending points out of it typically, and then sell the loan to another bank. We're just going to be doing what the big banks are doing and have the RMLO originate your loan, and then they assign it over to you. This passes the buck of liability to the RMLO and let them be accountable for making sure that it all went correctly. Because you don't want to open yourself up to the scrutiny with the state of becoming your own registered RMLO. I would never do that. Let somebody else do it. I'm going to read you the section that this pertains to. It's section 159.051. License or registration required. A person may not originate or make a wrap mortgage loan unless the person is licensed to originate. Under the sections, and it goes through the details of who you can get licensed with, but you just don't want to go down that path. Just use an RMLO. This next one is going to hurt a lot of my good friends, where it really shut the door on tabletop closings. It says verbatim that you have to use a title company or an attorney to close your transaction. I'll read you the language from the bill. The lien securing a wrap mortgage loan is void unless the wrap mortgage loan and the conveyance of the residential real estate securing the loan are closed by an attorney and or title company. It doesn't say they're voidable, able to be canceled. It says void, a void transaction. You don't want that. You've got to close through title or an attorney. Problem is, a lot of attorneys don't know how to do these transactions, and a lot of title companies, it's way over their head. Have that power team in place and the right people to work with, because you can work with a title company that knows how to do it, or an attorney that can structure it correctly, but don't think all of them can, because the majority in both those camps can't do it. Another really important part of the process here are having the correct disclosures. It requires you to disclose information at least 7 days prior to closing. What we do, we put these disclosures in our initial contract for agreement up front with our end buyer, so that they know at the day they contract all of these details. One of the things that the bill does state is that when the buyer signs the disclosures and acknowledgments, that it's not only signed, but dated. We use DocuSign, it does both of them. There are two disclosures that are really important. One is the insurance disclosure, to let your buyer know that if you as the seller have a policy, or your previous owner had a policy, any other policies don't protect them as an end buyer. And it is highly encouraged, recommended, and a best practice for them to go get and secure their own insurance policy. Personally, we don't do it that way at all. And we want to do it the big banks do, because if the big banks do it that way, you know it's okay. If you will get a loan for your property, you're going to have new insurance for the upcoming year in your name. That's exactly what we do for our end buyers. Whenever we sell a property to a new family, they get 1 year prepaid homeowners insurance at day of purchase. Part of their closing costs is acquiring that insurance, but it protects them. We still put the disclosure in our contracting process, but they go ahead and buy new policy the day they purchase the home. That is a best practice always. I will also be sure to mention and highlight the way you structure the homeowner's insurance for your end buyer could not be more paramount. It is seriously one of the biggest reasons the due on sale ever gets called. You as the lender cannot dictate what policy they get, but you can deny policies that they submit to you. So you always have to require that your end buyer lists your original seller, your underlying lien holder, your company, and themselves all on that insurance policy, because you're going to take that policy, submit it to your underlying lien, and get them to include that in the ongoing escrow. This process is complicated, but it's crucially important to making sure you don't get the due on sale clause called on you, and everybody's protected and safe. The other disclosure that's really important is the underlying loan or mortgage disclosure. You must tell your end buyer the name of your mortgage company for the underlying loan, the interest rate, the mortgage payment, PITI, contact information, sometimes even loan number. Was consent provided and approved by that lender? These details are important to having the correct disclosures that you give out to your end buyer. Again, we do this at contracting, so we more than meet the standard of the 7-day rule. It is also important that both of these disclosures, the underlying mortgage and the insurance, be provided to your buyer in their native language. Whatever language you negotiate the original agreement in is the same language that they should be provided these disclosures in. Don't negotiate the contract in Spanish and then give them only an English disclosure. That wouldn't be fair and not legal. The Senate Bill 43 does give you an out here, where if you've done a transaction in the last year and a half and you haven't provided these disclosures, you can still send them out to your end buyer. They have a time limit on how long they can get back to you, to where if they're unhappy, they want to rescind the transaction or any kind of problems with it. It is a little bit risky to shake the bear and send them the disclosure, but you had better do it, because the other consequences are orders of magnitude more significant. They can get back all of their principal, interest, all of their payments or down payment, their escrow money, 5-10 years down the road if they want to. Provide the disclosures. If you haven't, do it retroactively. Moving forward, do it every single transaction. One of the surprising parts and sections of this bill that I wasn't expecting as I read it, we talked about where the finance commissioner can send undercover agents out to determine if you're doing things unethically or illegally. Section 159.251 says the commissioner may conduct an undercover or covert investigation only if the commissioner, after due consideration of the circumstances, determines that an investigation is necessary to prevent immediate harm and to carry out the purpose of Chapter 158. So do things the right way and you don't have to worry about it. But we don't need undercover people snooping around. If you're on the right track, you won't have that problem. There's a lot more this bill talks about that I didn't go over for the interest of time, but it is more than worth your read to go over all the details. One of the nice things here is that if you did make a mistake and you forgot to do the disclosure, or you provide a disclosure and later your buyer decides they want to rescind and undo the transaction. Now, the best way to do that is to pay off your underlying loan. You will have to pay $1,000 in damages plus court costs plus reasonable attorney fees. If you don't have an ability to pay the underlying lien, you could sell the note. As long as your end buyer then pays off the underlying lien, you should still pay the $1,000 penalty and court legal fees for your buyer to settle the problem. I hope this was all helpful. It's great information. It's really, really important to make sure we do things legally, ethically, and create those win-win scenarios. Please like, follow, participate, give me your thoughts in the comments, and let's keep doing things the right way. Happy real estate investing. If you have questions about real estate investing, owner financing, or any other aspects, don't hesitate to shoot us a message or make a comment on a video. Don't forget to subscribe to our YouTube channel and follow us on the other social platforms to stay updated on the ever-changing real estate market. Happy real estate investing.